Today we learn about the difference between warranties and conditions precedent in a contract by examining the case of In re Carter's claim. Decided by the Supreme Court of Pennsylvania in 1957, Carter's claim touches on many concepts at the heart of important modern contracts, such as the concept of material adverse changes for merger agreements. A promisee has two ways to protect herself in a contract: warranty protection and condition protection. Non-performance of a warranty gives rise to breach of contract damages. Non-occurrence of condition allows a promisee to suspend its own performance. Failure of a condition affords a defensive weapon, an excuse, but does not give an offensive weapon, a claim for breach of contract. Phrased differently, a condition protection allows the promisee to get out of his or her own promises, whereas a warranty protection allows the promisee to actively sue for damages. Some have described a condition precedent as a shield, but not a sword. It gives rise to only a defensive protection, and the ability to withhold your own performance can at times provide stronger protections than the ability to sue for damages. Defensive protections can work forfeitures when the other side has already relied, and defensive protections don't require the hassle of going to court and winning a judgment. The plaintiff, the buyer, and appellant, Lester L. Cardon, entered into a 25-page written contract to purchase a Pennsylvania corporation and 5 of its subsidiaries, including the defendant, appellee, Edwin J. Schottel Company. About $187,000 of the purchase price was put in escrow to indemnify the plaintiff buyer against liabilities specified in the agreement. As we've studied before in Centronics versus Genicom, escrows involve an arrangement where part of the purchase price is held by a third party to compensate the buyer with effectively a reduced price if the seller's assets turn out to be worth less than expected. In the contract, listed under the heading of conditions precedent, was a term, paragraph 9, that said the financial condition of the defendant company shall be no less favorable at the time of closing than on June 30th, 1954, which was probably when the books closed at the end of the last financial year. As you know, the closing date refers to when the sale actually occurs, with title to the assets transferring to the new buyer. The plaintiff claimed that the financial condition was less favorable at closing and requested approximately $70,000 from the escrow. The parties submitted this to arbitration. The arbitrator awarded $3,182 to the plaintiff. Plaintiffs appealed to the Court of Common Pleas was denied, and the instant court affirmed. The main issue is whether the financial condition in this case was actually a warranty such that plaintiff is entitled to damages. The court held the agreement was carefully drafted and is clear that the provision in question is not a warranty, but a condition precedent. As such, plaintiff had the right to refuse to purchase because of the failure of this condition. But that option to refuse had to be made by the closing date. By accepting seller's performance and going ahead with the closing, plaintiff waived its right under the condition precedent. The court explained the result in terms of the, quote, plain meaning of the contract. In this case, the contract had the classic structure distinguishing between two clearly demarcated sets of provisions. On the one hand, there were representations and warranties, and on the other hand, there were conditions. The structure is found in most corporate contracts. A result explained in terms of plain meaning is justified where the agreement has been drafted with particular clarity, and the other party has failed to introduce evidence that the words used are reasonably susceptible to another meaning. The buyer waived the expressed condition by electing to go forward with the purchase at the closing date. The agreement also contained a provision, paragraph 5G, concerning value in the representation and warranty section. in which the seller represented that between June 30th and September 17th, 1954, there had not been, quote, any change in companies or its subsidiaries' financial condition, assets, liability, or businesses other than changes in the ordinary course of business, none of which has been materially adverse. The buyer warranted that this representation was true. How was the scope of this warranty different than the scope of the condition concerning value? Well, the warranty or promise of value was limited to changes in that were material adverse, quote, other than in the ordinary course of business, unquote. So reductions in value from the ordinary course of business would not constitute a breach of the warranty, but would be a failure of the condition that the financial condition of the company shall be no less favorable. Reductions in value from the ordinary course of the business would accordingly give the buyer an option not to buy at the closing date, but not the right to sue for breach of warranty damages. After the closing date, however, things change, and the buyer, if she chooses to close, is left solely with the offensive remedy of suing for breach under the limited warranty. Why would the parties write a contract giving the buyer broader defensive protections than offensive protections? Well, the parties might have expanded the scope of the warranty to allow breach of contract actions for any reduction in value, or they might have decreased the scope of the condition for only reductions outside of the ordinary course of business. Either of these changes would have rendered the offensive and defensive protections congruent, making them both conditions and warranty protections. The parties might have chosen, however, for asymmetric protections to constrain various types of buyer and seller opportunism. The parties might have realized that it was going to be hard to prove to a court whether the company experienced a reduction in value. The contract gave the buyers a broad right not to buy, but only allows the buyers to sue for damages if the seller does something outside of the ordinary course of business that hurts the firm value. So if a seller starts liquidating the equipment, that's outside the ordinary course of business, and the buyer can bring suit for a reduction in value from that stripping of equipment. But the contract gives the seller strong incentives not to do anything outside the ordinary course of business so as to limit the buyer's offensive rights. Instead, the contract in effect says, if the company's overall financial condition has worsened, then don't buy it if you don't want to. But if you still want the company, don't try to sue for damages. This form of asymmetric protection strikes a balance between two types of opportunism. You don't want the seller to run the company into the ground, but you don't want to allow the buyer to hold up the sale at the last minute. Although this case is over 50 years old, the warranty condition strategy is still employed to allocate risk between the date of contract and the date of the closing. In particular, buyers and sellers are worried about negative changes in the value of what's being exchanged between the contract date and before the closing. The warranty only covers changes in values that do not come from ordinary course of business. Condition covers changes from any cause. The contractual regulation of material adverse changes at the heart of In re Carter's claim has become one of the most hotly negotiated and litigated questions of merger law. Most friendly merger agreements contain material adverse change clauses. These are called MAC clauses, or sometimes material adverse effect, MAY clauses, which make the buyer's duty to buy conditional on there not being a material adverse change in the seller's financial condition. In recent years, merger agreements tend to include the traditional standard MAC or MAY terms, but also explicitly negotiated carve-outs that limit the buyer's ability to exit. The MAC and may provisions engender substantial litigation because it's hard for litigants to predict whether a particular negative event will be considered after the fact by a court as materially adverse. Sometimes contractual provisions are unclear whether they are creating promises or conditions. It's an interpretation issue where, if in doubt, the common law's preference is to interpret ambiguous provisions merely as promises, giving the promisee an affirmative offensive right to sue for damages, but not the defensive right to withhold your own performance. This is because a failure of a provision of a condition can produce inequitable forfeitures, where one side refuses to perform after the other side has substantially relied. For example, some contracts might include a provision saying, buyer shall notify seller of the place of delivery 2 weeks in advance of the shipment date. Is this provision a buyer promise giving rise to a breach of contract action if the notice is late? Or is it a condition relieving seller of the duty to ship if the buyer is a second late? Or is it both a promise and a condition? In one case, a buyer who had contracted to buy rice failed by 12 hours to give seller 2 weeks' notice. Because the price of rice was rising, the seller treated the provision as a condition and refused to perform. Courts will tend to treat ambiguous provisions as a promise and give the seller instead a breach of contract remedy and not as a condition, unless the contractual provision is more clearly conditional in its language. This preference for interpretation in favor of promises, however, does not apply to contracts, quote, of a type under which only the obligor generally undertakes duties, unquote. That's a quote from the Restatement 2nd, Section 227. Insurance is regarded as a contract of this type, where the usual interpretation is that the insured has no enforceable duty to pay premiums. Rather, if the risk insured against occurs, the insurance company's duty to pay under the policy is merely conditioned upon the earlier payment of premiums. Unless special arrangements with third parties have been made, however, the insured's failure to pay a premium is a failure of a condition rather than a breach of contract. Phrased differently, the insured's promise to pay the premium is treated as a condition precedent to the insurer's duty to provide coverage. Insurance is an odd kind of contract where the insurer's right to a premium is solely protected by the defensive right of the insurer to withhold performance, with no insurer offensive right to sue for a buyer's breach. Stepping back, we can see that promisee's right to a promisor's performance is protected in starkly different ways. An insurer's right to insurance premiums is protected solely by defensive rights. The buyer's right in Carter was protected before closing with larger defensive rights than offensive rights. But in Jacob and Young versus Kent, we learned that the substantial performance rule protects the buyer's right to Reading pipe with broader offensive rights than defensive rights. Because if you remember, in that case, a buyer could sue offensively for breach of promise, but was not allowed to withhold her own performance. In summary, there are two ways for a promisee to be protected in a contract. Warranty protection gives rise to damages, and condition protection gives rise to a defensive protection, the right to stop one's own performance. In determining whether an event is a warranty or a condition precedent, courts will usually rely on the plain meaning of the contract if the agreement is ambiguous. The interpretation favors promises instead of conditions in the interest of avoiding forfeiture. Protection and the ability to withhold your own performance can at times provide stronger protections than the ability to sue for damages. Defensive protections can work forfeitures when the other side has already relied, and defensive protections don't require the hassle of going to court and winning a judgment. Today we learn about the difference between warranties and conditions precedent in a contract by examining the case of In re Carter's claim. Decided by the Supreme Court of Pennsylvania in 1957, Carter's claim touches on many concepts at the heart of important modeling. A condition protection allows the promisee to get out of his or her own promises, whereas a warranty protection allows the promisee to actively sue for damages. Some have described a condition precedent as a shield, but not a sword. It gives rise to only a defense of modern contracts, such as the concept of material adverse changes for merger agreements. A promisee has two ways to protect herself in a contract: warranty protection and condition protection. Non-performance of a warranty gives rise to breach of contract damages. Non-occurrence of condition allows a promisee to suspend its own performance. Failure of a condition affords a defensive weapon, an excuse, but does not give an offensive weapon, a claim for breach of contract. Phrased differently,